Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2 of Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning because you have a criminal case in this court. This court handles misdemeanor cases. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally defined as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about is the facts of the case and the possible punishment that a person can receive after being convicted of the offense. Felony cases are divided into 5 categories, and we're going to start at the top and work our way on down. You have the capital murder, the first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If you're convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail. If you're convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life and a fine that does not exceed $10,000. And if you're convicted of a capital murder, the range of punishment is life without the possibility of parole or death by lethal injection. As I mentioned to you earlier, the case that you have in this court is not a felony case, it's a misdemeanor case. Misdemeanor cases are divided into 3 categories, and we'll start at the top and work our way to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. Now, your Class C misdemeanors are those cases that you normally see or hear about in the municipal court, which is the city court, or the JP court, which is the justice court. They handle Class C misdemeanors. However, if a person is convicted for a Class C misdemeanor in one of those courts, then they can appeal their case to come up to county court at law. And if they appeal the case, it comes to county court at law, it is still classified as a Class C misdemeanor. The range of punishment will be the same. Now, the range of punishment for a Class C misdemeanor is fine only. You can only be given a fine. Normally, the fine is up to $500. Now, if you fail to pay the fine, the court can convert your fine to community service. That is, you can work off your fine and court costs by working at a nonprofit organization in our community. Now, if you fail to pay the fine or if you fail to do the community service, they can issue what is called a capers pro fine. If they issue capers pro fine, if you do not pay the fine, you would have to sit out the jail time for the payment of that fine. The next level of misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, if you're convicted, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, and a fine that does not exceed $2,000. Or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in this county jail, or you could be given a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. I'm going to go over the rights that you have as a defendant in a criminal case. First right that I'm going to go over is on the tablet that you have been handed out. It's on the clipboard, and you have a right to have an attorney. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. And it basically states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. And number three, if you want to represent yourself, that is, you do not want an attorney to represent you, however, you want to waive or give up your right to have an attorney. If you desire to represent yourself, you may represent yourself. That's your third option. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. If you want an attorney and do not have enough money to hire an attorney, you would need to fill out a financial questionnaire. Now, the financial questionnaire is on that tablet. It should be the third form. It's titled Jefferson County Affidavit of Indigence. Now, you would have to fill out that financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to waive your right to an attorney, you'll have an opportunity to speak to one of the prosecutors. The prosecutor is an assistant district attorney who works for the Jefferson County District Attorney's Office. You'll have an opportunity to talk to them. Now, before you do that, before you can speak to the prosecutor about your case, you cannot speak to that prosecutor unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver is the second form on the clipboard. That document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. I will go over that document with you once I finish going over this first document. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status, and employment. If you choose to proceed without an attorney, that is, if you decide to waive your right to an attorney and represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. At the bottom of this document, the first document that is titled Judge's Explanation of Rights to Defendants Without an Attorney, it states in bold letters, defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to request that an attorney be appointed to represent you, then you will place your initials on the third line to the left. If you have already been appointed an attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, that is, give up your right to an attorney and represent yourself, then you will place your initials on the 5th line to the left. Now, once you have finished initialing one of the 5 lines, you will sign your name on the line that is titled defendant, and you will date it today's date on the line that is titled date. And today's date is September 12th of 2023. Now, for those of you who will be waiving your right to an attorney and representing yourself, the next document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea. And it states as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily, that is, nobody is forcing you to sign this waiver, and intelligently made. In essence, you know what you're doing. Furthermore, I have been advised this 12th day of September of 2023 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that is your choice, then you will sign your name on the line that is titled on the line that is titled defendant, and you will date it today's date, September 12th of 2023. Now I'll proceed to other rights that you have. One other right that you have is a right to have a trial by a jury. For those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence, the arguments, and then they will deliberate. And then after deliberating, they will decide to find you not guilty or guilty. You also have a right to waive or give up that right to have a trial by jury. And if you waive or give up your right to have a trial by jury, your case will come before this court in one of 3 ways. One way it can come before the court is by way of a bench trial. And what a bench trial is, it's a trial before a judge only without a jury. And the judge will listen to the evidence, listen to the arguments, and then the judge will decide to find you either not guilty or guilty of your charge. The other way that your case can come before the court is by way of an agreed plea bargain agreement. And what that is, a plea bargain agreement, is that you and the state, the district attorney's office that is, has worked out an agreement to settle your case. We call that an agreed plea bargain agreement. And if you and the state have worked out an agreement to settle your case, then the case will come before the judge, and the judge can either do one of 2 things. The judge can either accept the agreement or reject the agreement. If the judge accepts the agreement, then at that time, if you decide within 30 days you want to appeal, you have to get permission from the judge or the court to appeal your case. And if the judge gives you permission, your case will go up to the 9th Court of Appeals, and they will review the case and to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. And they can either grant or deny your appeal. Now, if they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than the 9th Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is the Texas State of Criminal Appeals located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. Pro se means you'll be filing this on your own without the assistance of a lawyer. You'll be asking them to review your case to see if your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not this court committed an error by convicting you. They can do one of two things. They could either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Or they could send the case back to the Ninth Court of Appeals or send the case back to this court in order that you be given a new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, the third way that your case will come before the court is by way of an unagreed plea bargain agreement. Now, you have an agreed plea bargain agreement, but now you have an unagreed plea bargain agreement. And what that simply means is that you and the state have not been able to reach an agreement to settle your case. And so you want the judge or the court to decide what your punishment will be in your case. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. And what witnesses do, they can testify either for you or against you. You or your attorney, depending on if you represent yourself or if you have an attorney represent you, they can be asked questions. We call that either direct examination or cross-examination. Now, you can waive or give up that right as well. Now, by waiving or giving up that right, that simply means that you will not be calling witnesses in your case. It does not mean that the state will not be calling witnesses in your case, because they will be calling witnesses in the case that they have filed against you. You also have a right, we call that a Fifth Amendment right against self-incrimination. That is, you have a right not to testify in your case. With the Fifth Amendment right against self-incrimination, the state of Texas, the government, the DA's office cannot force you to testify in your case. In essence, they can't call you to the witness stand as long as you invoke your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And by doing so, you can testify in your case. You also have a right to have what we call discovery. Discovery means that you have a right to see the evidence that the state has and that the evidence that the state will be using against you. You have a right to have access to that evidence. That is, you have a right to see the documents, witness statements, your statement. You have a right to see reports, lab reports. You have a right to see videotapes, listen to audio recordings. You have a right to have access to either some instruments that they may have or whatever evidence that they have that they'll be using against you in your case. You have a right to have access to that evidence. Now, you can waive or give up your right to have access to that evidence as well. You can waive your right to discovery. Now, everyone that's here for arraignment, you've been arrested and you're out on bond. And when I say you're out on bond, you're either out on a cash bond, which means you pay the full amount to get out of jail, or you're out on surety bond, which means you pay the bondsman a percentage of that bond to get out of jail, or you're out on a PR or a personal recognizance bond, which means that you did not pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear in court. Now, every day that you have spent in jail on your case, you can receive credit towards your punishment. So, for example, let's say you spent 5 days in jail, and let's say you and the state have come to a plea bargain agreement. They want you to serve 5 days in jail. What that means is you will not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, if the state is offering 7 days in jail and you served 5, that means you only have to serve 2 more days in jail. Every day that you spent in jail can also be credited toward your fine and court costs. You receive $100 per day that goes towards your fine and court costs. So, for example, if the state is offering you a fine and court cost of $500, you spent 5 days in jail, that means you won't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired, which means you won't have to pay it. Now, if they offer fine and court costs of $700, you spent 5 days in jail, $500 is going to be credited toward the $700. That means you have $200 to pay, and you'll have to pay it on the day of the plea. However, if you do not have the money to pay the $200, then the court can convert your fine and court costs to community service. And what that means is you'll work at a nonprofit organization in the community, and every hour that you work, every 1 hour that you work, $12.50 will go toward your fine and court costs. So, for example, if you work 8 hours one day, that's $100 that will go towards your fine and court costs. Okay? So, with the example, if you work 2 days, 2 8-hour days, that's $200 that pays off your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion. It's for first-time offenders, people who have not been in trouble before. With that program, the district attorney's office will dismiss your case. And if you complete the program, you can get it expunged from the record. Expunged means you can get it erased, deleted, or wiped off your criminal record. Now, in order to qualify for the program, as I mentioned earlier, it has to be your first offense. You can't have a criminal history. You have to have an attorney to help you, to assist you at making out the application to get into the program. And the third requirement is it cannot be an offense for unlawfully carrying a weapon or resisting arrest. All other offenses, you can apply. This court, well, there's another program that the district attorney's office has. That program is called Veterans Court. With the Veterans Court program, that program is for veterans only. Now, if you are a veteran of any one of the branches of the United States military, you may qualify for Veterans Court. And with the Veterans Court, you get into the program, you complete the program, they will dismiss your case, and you can get it not expunged, but you can get a non-disclosure. And what a non-disclosure is, we cannot disclose the fact that you had this charge to the general public. We cannot disclose that fact. Now, governmental agencies can have access to that, but the general public cannot have access to it. Okay. Now, this court has a program that is called the CSI program. The CSI program stands for Community Safety Initiative. It is a program that is designed to address the issue of what we call recidivism. Recidivism means when people commit crimes over and over. And so how do we address the issue of recidivism that prevent people from committing crimes over and over? Well, we have the Community Safety Program. That is a program that I started within the first 100 days of taking office. That program started in March of 2017. So we've been having that program over 6 years. With that program, we have partnerships with local agencies in our community. One of the agencies that we have a partnership with is Spindletop. Now, the people that I pointed out to you in the jury box, they're from Spindletop. They're going to come to you in a little bit and tell you more about the program that Spindletop has to offer. But generally, what Spindletop does, they'll be able to do private interviews. They can either do it in our jury room, or they can do it at their facility, or it can be done over the phone. Now, they can develop a treatment plan. They can do an assessment, develop a treatment plan, either outpatient or inpatient services, depending on what your mental health needs are. Now, you do not have to be incompetent. You do not have to be insane to participate in the program that they have, okay? You can just suffer from any type of mental illness, let's say depression, let's say anxiety, or what have you. They'll be able to address those issues. The other thing is Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. The local Drug and Alcohol Council has a program that is called OZAR. OZAR stands for Outreach, Screening, and Referral. Both of those programs are similar. And what they'll do a private screening, and they'll do an assessment. You could either be referred for either outpatient or inpatient treatment for any drug or alcohol issues that you may have. If you are unemployed and do not have a job, well, we have a partnership with the Golden Triangle Empowerment Center. Golden Triangle Empowerment Center has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. What that is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. They will train you in one of the areas that you select. And then they will help you to get a job in the area that you're trained in. If you have not graduated from high school, they also have a GED program, Graduate Equivalency Diploma. With that program, you can get your high school diploma. Now, all of these programs that I just mentioned are free. It does not cost you anything but time. The other benefit is all of these programs can be used as community service. So, for example, let's say you are ordered to pay a fine and court costs. You cannot pay your fine and court costs. We converted to community service. And let's say you have an issue, you're looking for a better job, you're in the job training program, you get community service. Every hour that you're in class, that goes toward $12.50 will go toward your fine and court costs, and 1 hour will go toward community service. Or let's say you're getting mental health treatment at Spindletop or drug treatment at ATAR or OZAR. Every hour that you're getting the treatment or counseling, then 1 hour will go toward your community service, $12.50 will go toward your fine and court costs. So I like to say you're doing three things. You're doing one thing, but you're getting credit for three. It's like killing three birds with one stone. Okay, you're in the program, you're paying your fine, and you're getting community service. By doing one thing, you're getting credit for three things. And also, as I mentioned earlier, in this court, we do not just give time, we take our time. That simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I tell people this all the time, when you come to county court at law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in the lives of the individuals that comes before this court, we'll make a difference in their home. And if we make a difference in their home, then we'll make a difference in the community. And so the program is designed to produce productive people. And so, as I mentioned to you earlier, we have our folks from Spindletop. They're going to come. We have Gabby, Deputy Hinton, who's going to come to talk to you. We also have another guest who's going to come, and they're going to come and talk to you about the program that they have to offer here in Jefferson County. Deputy Hinton and Gabby. Y'all may come forward.
Thank you, Your Honor.
You welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state. I'm here commission with the sheriff's department here. This is my coworker Gabby. Now, Gabby is a qualified mental health professional with Spinal Tap. The reason we are both here this morning is because the judge has graciously invited us in his courtroom because he cares about every single person who comes before the bench. What the judge has found and what statistics prove is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you.
So we're talking about, mental health needs, we're talking about maybe it's problem anxiety everybody has. And it doesn't help that when you come in the courtroom, you can rise a lot of anxiety also. This can be depression, or just lack of community support. If you don't have support during this time, we recognize that it is difficult and it's lonely and it's hard. So we're here to offer that help. And so, yeah, if you can share that need, that is what we're here for. Once everything, it can be financial, it can be clothes, food, we want you to share that.
And maybe this is your first time to be here, maybe it is your 10th time to be here, there's still hope. What we're offering you today has the ability to change your life. However, we're gonna need something from you. We're gonna need you to share that need with us. And Gabby's gonna explain how you can do that very privately. We're not here to embarrass anyone, but we're gonna need that information to see how to best advocate and best serve you, if that's something that you would see value in.
So it's the sheet that we gave you that I passed out when y'all were sitting down. This is how you're gonna share that need for us. This serves as kind of like a tip of consent, which means only you're gonna see this. The people who are gonna contact you is gonna be me on my work phone. It's not gonna be anybody automated. It's not gonna be some robocall that's gonna keep blowing you up. This is gonna be just a one-time thing. If you don't want us to contact you anymore, that's totally fine, but this just allows us to talk to you once and reach out to you once in a matter of your choosing. There's gonna be 2 boxes up here. It's gonna be call or text. Pick which one you want also. And then right under it is gonna be the resources you're interested in also. And so we really need y'all to please put the need that you need, even if it's just support or financial. We'd like you to share that with us if you'd like. And at the bottom, it's gonna ask if you would like to talk with us today, if you want to share anything with us today, or if you're just feeling and you just need to see a break just to breathe real quick, you can do that also.
So I also have this flyer that I want to give everyone before you leave here today. On the back of it tells you a little bit about the advantages and services we provide. But also it has a 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. Shortly, the court is going to go into recess, and when it does, we'll be able to come out there and visit with each one of y'all. We'll pick up the form that Gabby's already handed out. And we'll also, I'll get this in your hands at the same time. If you want to talk, there'll be an opportunity that we can visit with you and spend a little more time with you, if that's something that you see value. Thank you. Thank you very much. Thank you, Your Honor.
Thank you, Deputy Hinton and Gabby. Now, ladies and gentlemen, the paperwork that's on the clipboard, we're gonna pick up the clipboard from you in a few minutes. Now, if anybody needs any help, we have our court personnel who will be here who's here to assist you at filling out the paperwork. We need to make sure that the paperwork are filled out properly so that we can evaluate them like we should evaluate them. Now, the other thing is, this is going to take a few minutes for us to gather the paperwork, evaluate them, and then we're going to call you up before the bench one at a time. And then once we do that, once we call you up to the bench, we'll let you know at that point that you'll be free to go. But as I mentioned earlier, it's going to take a few minutes to do what we need to do. So if someone needs to use the restroom, there are 2 restrooms that's right outside in the hallway. The men's restroom is in front of County Court at Law number 3, which is next door. The female restroom, or the women's restroom, is on the opposite side of the hall in front of the 172nd District Court. So at this time, now, let me mention this to you. Please do not leave the courthouse. Because if you leave the courthouse and we call your name, you're not here, a warrant will be issued for your arrest. And eventually you'll be arrested and placed in Jefferson County Jail, and we'll have to do this process all over again. Okay? So at this time, our court will be in recess.